In 2004, Congress passed the Unborn Victims of Violence Act. That law allows prosecutors to bring separate charges when a pregnant woman is harmed and her unborn child is killed during the commission of a crime. In doing so, federal law recognized something crucial. It recognized unborn life as a legal victim. Yet, despite this, federal law has failed to consistently define when personhood begins. The resulting contradiction raises a necessary question. If unborn life can be recognized as a victim in certain legal contexts, why then is there no consistent federal definition of that status across the rest of our legal system? When the law treats the unborn as a victim in one context, but not in another, it creates a legal and moral contradiction that must not be ignored. We must ask ourselves, how did we reach a point where ending the life of an unborn child can be treated as routine, while harming that same child in another context is treated as a tragedy? When the most basic categories of legal protection are applied inconsistently, the result is a failure to provide the equal justice and protection that all human life is meant to receive under our laws. Today, I want to examine why this inconsistency exists, look at how it affects federal law, and demonstrate why Congress should adopt a federal statute establishing legal personhood as beginning at conception. Now, to understand why a federal personhood statute is needed, we must first look at how inconsistently the unborn are treated under current law. The Unborn Victims of Violence Act defines an unborn child as a member of the human species at any stage of development, as explained by John Shimbukuro of the Congressional Research Service. Under this law, harming a pregnant woman and her unborn child can result in two separate charges, one for the mother and one for the unborn victim. States follow a similar pattern. According to the National Right to Life Committee's 2025 Summary of State Homicide Laws, 39 states recognize the unlawful killing of an unborn child as homicide in at least some circumstances. These laws allow prosecutors to charge offenders with homicide or manslaughter for the death of an unborn child. Yet, despite this, legal recognition of personhood remains inconsistent. Criminal law may treat the unborn as victims, while other areas of the law do not. Johanna Hussein notes in the Cornell Journal of Law and Public Policy that this inconsistency creates confusion for courts, policymakers, and citizens. And this inconsistency becomes unavoidable when we talk about the issue of abortion. If the unborn can be a victim of homicide in one legal context, but not in another, the law is honestly speaking out of both sides of its mouth. A society cannot logically say that the unborn child is a victim when a violent offender ends its life, but somehow not a victim when a medical professional does so intentionally. It is a logical contradiction that exists because the federal law has no unified definition of when legal personhood begins. Courts have struggled to interpret laws involving the unborn because personhood is not defined uniformly. Elizabeth Harmon explains in the Stanford Encyclopedia of Philosophy that scholars disagree about when moral status begins, and that this disagreement contributes to the inconsistent legal interpretations. Improvements in prenatal imaging and fetal medicine have expanded what is known about early human development. Jasna Miklovic and Philip Flauman argue in the Journal of Pregnancy and Child Health that the zygote, embryo, and fetus are biologically members of the human species from the moment of conception. These developments have influenced some state laws, yet federal law lags behind. And abortion exists in the middle of this legal vacuum. Without a federal definition, courts cannot resolve the tension between fetal homicide laws and abortion. And beyond the legal confusion, there is a deeper cultural and moral confusion that must be addressed. We live in a society where people are horrified by the mistreatment of animals, and rightly so. We recoil at the thought of someone harming a puppy. We pass laws to protect endangered species, and we do things like celebrate rescue shelters or adoption programs. Yet somehow, when it comes to the unborn, members of our own species, the law suddenly becomes silent and unsure. This contrast forces us to confront a difficult truth. Our compassion is inconsistent, and our current laws reflect that. Congress has the authority to define terms used in federal law, as demonstrated by the Life at Conception Act introduced in the 118th Congress. As Hussein explains, Congress has historically defined legal categories such as citizenship, civil rights protections, and classifications under federal law. For example, at one point in American history, black Americans were not recognized as full legal persons under federal interpretation. In Dred Scott v. Sanford, the Supreme Court held that black Americans could not be citizens and therefore lacked standing in federal court. Later, that legal framework was rightly rejected through constitutional amendment. It was a correction to a legal system that had failed to justly recognize personhood. Under coverture doctrine, women were historically not treated as fully independent legal persons in marriage, with their legal identity absorbed under their husbands. Now, over time, that structure was dismantled as the law caught up and recognized the inconsistency between that framework and equal legal status. Our government has the capacity to correct against past injustices, and a personhood statute would function similarly by defining who is protected under federal statutes. A federal definition would strengthen legal protections for vulnerable life and ensure that unborn victims of violence are recognized properly. It would establish a coherent national standard rather than what we have now, which is essentially a patchwork of conflicting state laws. We need to confront abortion honestly. The termination of a developing human is simply wrong. In the U.S., just over 1 million unborn children are terminated every year, according to statistics provided by the Guttmacher Institute. This cannot continue, not if we're a nation concerned with justice. If the unborn is legally a person, then federal law must treat the unborn consistently across all contexts. Now, some critics argue that personhood legislation would create legal chaos, but the current system is already chaotic. It is chaotic to treat the unborn as a homicide victim one moment and somehow as a non-entity the next. It is chaotic to leave the most fundamental legal question, who among us qualifies as a person, undefined. A personhood statute would bring clarity, not confusion. Now, so having examined the need for a federal personhood statute, I think we can now consider what this change means for the future of federal law. A federal personhood statute defining legal personhood as beginning at conception is the solution. This issue goes beyond classification policy. History has shown us the consequences of failing to value life equally. A nation that recognizes the unborn as victims of violence should not deny their status in other areas of law. A nation that values justice should not tolerate contradictions that leave the most vulnerable without protection. I believe this to be the greatest tragedy of our generation. Too many lives have already been cut short. Congress must immediately recognize life as beginning at conception.